Is a landlord allowed to run a criminal background check on a prospective residential tenant in Cook County, Illinois? This is a question I've been getting lately, and it's in response to what's known as the Just Housing Amendment to the Cook County Human Rights Ordinance. Now, the answer to this question is yes. A landlord may run a criminal background check. However, it's complicated. In fact, it's far more complicated than it needs to be, in my opinion. But as I always say, we don't make the rules, we simply adjust to them and advise you accordingly. Under the terms of the ordinance, which went into effect as of February 1st, 2020, a landlord may, but is not required, to run a criminal background check. However, when doing so, a landlord is required to follow certain procedures and guidelines. First and foremost, before a landlord may proceed to doing a criminal background check, a landlord is required to put a tenant through what's known as a pre-qualification process. This is where a landlord will check a tenant's credit history, their job status, etc. If a tenant passes all criteria other than criminal criteria, then and only then may a landlord proceed to doing a criminal background check. Now, even at this stage, there are further guidelines that the landlord needs to follow. For one thing, a landlord can only consider criminal convictions. A landlord may not consider mere arrests. And a landlord is only supposed to consider criminal history that is within 3 years. A landlord is not supposed to consider criminal history that is older than 3 years. If a landlord happens to find criminal history that's within the 3-year time period, there are further matters a landlord is supposed to take into consideration. A landlord, for instance, is supposed to consider any efforts that a potential tenant made at rehabilitation. These include things such as completion of a GED, completion of any post-conviction requirements imposed by a court, steady job history, etc. Now, if a landlord finds that a tenant still does not qualify, a landlord may then deny housing to the potential tenant. But the tenant still has the option of challenging the landlord's findings, and the statute sets out some procedures and timeframes whereby a tenant may do that. As with any ordinance, there are always exceptions. A landlord need not follow this ordinance if a potential tenant is required to register under the Sex Offender Registration Act, or if a tenant has restrictions imposed upon them for any kind of child sex crime. Also, if there's any specific instances where a landlord can identify concerns that raise the question of whether or not a tenant poses a specific danger to other tenants, etc., a landlord in those instances need not follow the terms of this ordinance either. This is something to be very careful with. There are penalties laid out in the ordinance for not following it properly. A landlord could be hit with compensatory damages, fines. A landlord could be liable for attorney's fees. So this is something you want to take very seriously. I urge any Cook County landlord to have a look at the ordinance. It's not a hard ordinance to read. It's not shrouded in complicated legalese, and it's something you can make your way through very easily. Of course, it's not meant to replace the advice and counsel of your attorney. We've been working on these matters for many years, and we're happy to assist. If you need help in this area, give us a call.